Before we get going, I have a document I'm prepared to share with all the, I only have one copy of it, and so maybe the press or media present can use some photocopy facilities here as they want it, but it's essentially in a nutshell, the case that was before the Supreme Court of Canada that they declined to take, so that you can see the actual legal formulation.
Actually, I'll try to get it done before now, but you help us start.
Right now?
Yeah.
Okay. All right. We're here today to speak on behalf of Dr. Diab and his family and to give them a voice. And I'm speaking frankly to you from 43 years of experience in criminal law in this country. Unfortunately, in this case, we now have, in my view, a classic recipe for the wrongful conviction of a Canadian. As the Canadian judge held, who heard the evidence in this case that France offered, because of the weak, and that's his word, weak, and suspect, that's his word, suspect case that France presented against Dr. Diab, the judge went on to say if a fair trial is held, conviction will be unlikely. Now you bear in mind, criminal trials are done on the basis of beyond a reasonable doubt. This is not even likely, not even probable. There are two bases to the case against Dr. Diab that I want Canadians to understand. And the first, the only basis that the Canadian courts used to extradite Dr. Diab to France, which would not, by the way, extradite its citizens to Canada, is a handwriting comparison done years after the fact of 5 block printed words on a hotel card, not cursive written, but block printed. And this is what the Canadian judge said about that handwriting analysis. Quote, "It is illogical." Quote, "It is very problematic." Quote, "It is convoluted, very confusing, with conclusions that are suspect. Does this sound like reliable evidence to you?" What were the details of this handwriting analysis? France offered initially 2 supposed handwriting experts, and I put that in quotes, who compared these 5 printed words with the writings at Syracuse University where Dr. Diab had done his PhD, and purported to identify the person who wrote those Syracuse compared documents, the admission documents for the doctorate program, as the printer years and years before of the 5 words, the suspected criminal. The problem was the person who actually wrote the Syracuse documents, or the Syracuse documents that the French experts compared, was not Dr. Diab at all. It was his wife. She was identified by these French expert handwriting analysis people as the 40 to 45-year-old man who had signed in at the hotel. 40 to 45-year-old man is being identified by the handwriting as a woman. Hassan Diab, I hasten to add, was at that time in 1980 in his mid-20s. He wasn't a 40 to 45-year-old man. And I also point out that the evidence in this case shows that a fingerprint on a police statement taken in France from the suspect man does not match Hassan Diab. Embarrassed, France had to retract the evidence of these 2 alleged experts, and instead of withdrawing their application to Canada to extradite Dr. Diab, France then, much later, offered a replacement expert for the first 2, and this one too, now, using writings of Dr. Diab, said her opinion was also that Dr. Diab penned the 5 words. There are 2 basic starting points about this opinion before we get into what the court found about it. The first is all credible handwriting analysts worldwide agree you cannot compare block printing with cursive writing. And secondly, the separation of decades of years between those block printed words and the Syracuse comparison materials means you can't reliably compare at all. So on top of those two basic principles, then the court in Canada had and has before it 5 of the world's leading experts in handwriting analysis, the evidence. 1 from Canada, 1 from the United Kingdom, 1 from the United States, and 2 from Switzerland, who are experts in the French criminal justice system. And they gave unanimous evidence to the Canadian court that this replacement handwriting evidence offered by France, and these are their words, was wholly, meaning completely, unreliable, fatally flawed, totally unreliable, because the accepted methodology in the field had not been followed by this supposed expert. This is like someone who claims to be offering an opinion on cardiac surgery using the methodology for liposuction. Reliability is rooted in methodology. That led that evidence, combined with the other problems that I've described, to the Canadian judge saying that the evidence that France relied on was illogical and their entire case was suspect. That's the only evidence this case turned on. These are findings and words of a Canadian judge that we see in wrongful convictions being overturned years or decades later after Canadians have suffered. But in this case, we have them being said before, when we can prevent this. There's an added element or aspect to the unfairness of what is happening to Hassan Diab and the wrongful conviction potential here. In France, they will add to this illogical, suspect, totally unreliable handwriting opinion evidence secret intelligence. This intelligence was withdrawn from the court in Canada by France because it would obviously violate the charter, and the court heard evidence from experts about how you can't have a fair trial using such material. But France actually uses secret intelligence from unknown sources in unknown circumstances as evidence. And Human Rights Watch and other respected international organizations, groups, and NGOs have decried this French practice as leading to unfair trials and unreliable verdicts. And that's because intelligence is not evidence. Think of the invasion of Iraq and weapons of mass destruction. What is the source of intelligence? Is it a person? Nobody knows. Is it the opinion of some intelligence analyst? Nobody knows. It's secret. Where would such an intelligence analyst be from? Syria? Egypt? The former East Germany? Is it the product of torture? Nobody knows. This could never meet Canadian constitutional standards for criminal trial. Yet we're sending a Canadian to such a Kafkaesque trial where he can't possibly meet the standards of knowing the case against him and making and having a real and meaningful opportunity to answer that case. You can't answer and know what you can't know. So it's a profoundly disappointing day in this legal journey. Dr. Diab and his family, his wife Rania, his daughter Jenna, hope Canadians will pay attention to the state of their extradition law in this country. For Dr. Diab and his family, the promise of the Ferris decision of the Supreme Court of Canada a number of years ago in 2006, a promise that extradition of Canadians would only occur on reliable evidence, for them that promise has been broken. And they ask Canadians this: does illogical, very problematic, convoluted, very confusing conclusions that are suspect sound like reliable evidence to you? Thank you.
So you have the 10 minutes, so very briefly. How long? 2 minutes.
My name's Colin Stewart. I'm a member of the Justice for Hassan Diab Committee. I have been asked by Hassan, who's now in a prison cell at the Ottawa Detention Centre, to read the following statement. I am deeply shocked that the Supreme Court refused to even hear the appeal in my case. This is a very sad day for me, my family and supporters, and the state of extradition law in Canada. I had hoped for justice from the Canadian legal system. I have been living a Kafkaesque nightmare for over 6 years, fighting false allegations against me, enduring detention, strict bail conditions, the loss of my employment, and an enormous stress on my family. It is beyond devastating that the Supreme Court would allow my extradition for a crime that I did not commit and based on a handwriting analysis report that was shown by world-renowned handwriting experts to be wholly unreliable, totally erroneous, and biased. It is shocking that this would happen in Canada. The numerous commissions on wrongful convictions based on faulty forensic evidence and the court's vow to never let this happen again. I, my family, friends, and supporters will continue to fight the false allegations that have been imposed on me, a Canadian citizen who is law-abiding, peaceful, compassionate, and who abhors violence. I am grateful and heartened by the outpouring of support from thousands of individuals and organizations that recognize the injustice that I have experienced and the unfairness of Canada's extradition law. I am also deeply thankful to my devoted lawyers who tirelessly worked on my behalf for years. I vow to never give up, and I will always remain hopeful that I will eventually return to my home in Canada and be reunited with my wife and children. Thank you.
Good afternoon. My name is Jackie Kennelly, and I'm a professor at Carleton University, a colleague of Hassan's and of Ranya's, his wife. And I'm just here to speak a bit about the academic support that this case has had. Yesterday, we sent in a letter to the Minister of Justice with over 400 signatures from Canadians, mostly from Canadians as well as from people across the world. Over half of those were from people who identified as academics, as university professors. We had fellows of the Royal Society of Canada, we had Canada research chairs, we have deans of law, we have medical doctors. And in short, we have a number of people who are appalled and outraged by the way in which this case is played out, the injustice that is happening. And I think this is true of the majority of Canadians, but I'm here to highlight the fact that we're talking about the most educated elites in our country who are saying that this is an absolute travesty. I just wanted to be sure to raise your attention. Since yesterday, the letter has continued to circulate, although we sent it into the Department of Justice, and it's already gleaned another 120 signatures in the last 24 hours. So that's all I wanted to highlight today. Thank you very much.
I'd like to know if you can answer in French, how does Mr. Diab feels right now? Have you spoken to him? How does he feel?
So my French is limited, but I would say il est vraiment désolé et il a peur.
And I'd like to know what's the problem with sending someone to France for a fair trial? It's not Zimbabwe, it's not a dictatorship right there. It's a democracy. There's a justice system. It's like there's no death penalty. So what would be the main problem there? He was going to have a fair trial. He might be guilty or not, but there's a fair trial waiting for him.
Well, I tried to explain that in my remarks. They use secret intelligence as if it's evidence and give it credit. And they will, we are advised, give this unreliable handwriting. It comes from their court-appointed experts. They're going to treat it as if it's reliable. The writing is on the wall.
My understanding is he will now face a judicial inquiry. It's obviously different than what we have in Canada, but perhaps you could walk us through what he will face next.
Fair question. His circumstances are very unusual. When Canada enacted its extradition law, it was clear from the parliamentary debates and the statements of legislators that Canadians were only to be extradited to face criminal charges, face a criminal trial abroad. Dr. Diab, it is clear from the French materials, is not facing trial. He's not being extradited for trial. He's being extradited so that they can keep him in jail and have about 2 years, I am advised by French lawyers, of investigation. And this is what was initially not supposed to happen. Canadians are not supposed to languish in foreign jails while investigations are going on. If they have a case ready to go to trial, then they consider the extradition request. And even then, as you've heard, the evidence in this case doesn't merit extradition.
Is it possible that he could be questioned, that if he is indeed innocent, be released in a short amount of time?
He has offered to meet with French officials here and be questioned, and never been taken up on it.
That offer consist of with what officials did he agree to meet in Canada?
No, French officials, the French investigators.
Would magistrates?
The investigating
police?
magistrate, yes.
Given to not accept, like to not.
There was no reason given. There was no response.
Given everything you've said and given what we know about the evidence, and given that he is not being charged yet and is not facing a trial, which explicitly it says in the law that those would be the conditions for extradition, why do you think the Supreme Court made the decision that it made?
I'm not here to second guess. There are no reasons given. Our system of justice is a wonderful system of justice, and but wrongful convictions occasionally occur, and I'm terribly concerned for the reasons I outlined that this case has wrongful conviction written all over it.
Is there anything you can do legally now to try to prevent his extradition, or is that it?
That's it.
The solution would be changing the actual law or changing the process, or
Part of the process is making Canadians aware of what is essentially a backwater, little known by them and most practicing lawyers in our criminal law, namely the law of extradition. Secondly, it's making sure the courts have the courage to really apply charter standards, including the requirement of reliability. The fairest judgment, if you read it, is a fine judgment, and it promises constitutional reliability before anybody is extradited. Unfortunately, it's been whittled down so that we're back to the days where they've made rubber stamps out of the presiding extradition judges, and that's a tragedy.
Can I speak to a couple of the questions? I just wanted to comment on, I don't know, I'm not a legal expert, and so I definitely wouldn't want to, Dawn knows more about this process, but I think if we're considering, the question of why weren't French authorities willing to meet with Hassan here, why has this case carried through even though there seem to be these kinds of blatant problems with it? We do need to understand the political context in which we're in right now, right? We're in a context in which there's this sort of fight against terrorism, or the way in which these things are framed. Hassan Diab is a Canadian citizen, but he's of Lebanese descent, and there's definitely concern amongst myself and my colleagues and the people who have spoken out in support of this, that this is part of a kind of a bit of a witch hunt, a terrorist witch hunt, and that Hassan has gotten innocently caught up in the nets of this, and this is one of the things that we're really worried about, that when we play out the legal process and we're all shaking our heads about how it's even gotten to this point. I feel like, what the rest of us, what us in academia, we're trying to make sense of it. And as we look at the political context of the fight against terrorism and say this has ultimately become a political decision. I don't know, Dawn, if you would agree with me, or Colin, but I think it's important to state that.
Just a quick comment that earlier on, several years ago, when this case was before the lower courts, we knew, and I think it continues to be the case, and Dawn can clarify this, that the Minister of Justice does have some discretion in this matter. He can make a decision, but he failed to do so to relieve the burden of this false extradition process. Thanks.
going to be transported within 45 days, I understand, and will be handed over to French authorities.
Yes.
Quick question about one of your other clients.
No.
You-